Hello, everyone. My name is Ron Hood, and I am a co-chair of the CBA's Diversity, Equity, and Inclusion Committee and a past co-chair of the Constance Baker Motley series. During most days, I am an attorney at Bartlett and Grippy in Cheshire, Connecticut, where I practice mainly insurance defense, personal injury, and civil litigation. It's my pleasure to welcome you all tonight to Race, Pretrial Detention, and Disparate Outcomes, which is a part of the Constance Baker Motley series on racial inequality established by the Connecticut Bar Association and the Connecticut Bar Foundation. We look forward to continuing to explore topics related to racial inequality. Constance Baker Motley was a trailblazing civil rights attorney who became the nation's first African-American female to serve as a federal judge and later chief judge. Judge Motley was born in New Haven, Connecticut, and maintained strong connections to Connecticut throughout her life. Today's session is entitled Race, Pretrial Detention, and Disparate Outcomes. Research on pretrial detention confirms through statistics that stark racial disparities and practical realities of who is held in pretrial. This panel discussion will explore that research, laying out the framework for these decisions as well as the risk assessment tools used as part of the calculation. We will discuss how the limitations of these risk assessment tools lead straight to inequality in the ultimate outcomes for these cases, and whether there is anything in the process or at the state legislative level that we can do to fix it. Now, without further ado, I will turn it over to tonight's moderator, Attorney Cody Guarnieri.
Thanks, Ron. I'm Attorney Cody Guarnieri. I am a trial attorney at Brown, Payne, Dearest, and Scott in Hartford, and I very much appreciate being your moderator today and the trust of the CBA and the CBF in asking me to be your moderator. Before I get started with introductions to our panelists, I know this is going to be a very interesting discussion. I know we have a large number of attendees as well, which is a wonderful thing. And I just want to invite everybody throughout the course of the discussion to put any questions that you would like to have raised in the chat feature. And if it makes sense in context, I would be happy to try to address those as we go along. I would note that in the chat feature, there is an option so that you can address the questions to just the host and panelists if you don't want to address your question to the entire participation tonight. So we are very honored to have our panelists. I'll start with the United States Attorney for the District of Connecticut, Vanessa Roberts Avery. She's the 54th United States Attorney for the District of Connecticut, which she became on May 9th of 2022. President Joe Biden nominated Ms. Avery to serve as U.S. Attorney on January 26th of 2022, and the U.S. Senate confirmed her nomination on April 27th of 2022. Under Ms. Avery's leadership, the U.S. Attorney's Office continues to prioritize investigating and prosecuting a variety of federal crimes and suspected violations of federal law. Prosecutions and investigations by the U.S. Attorney's Office and its federal partners are often coordinated with state and local law enforcement, and community engagement is a critical component of law enforcement responses under U.S. Attorney Avery. Prior to her appointment as U.S. Attorney, Ms. Avery served as the Associate Attorney General for the Chief of the Division of Enforcement and Public Protection at the Connecticut Office of the Attorney General, and was previously an Assistant United States Attorney in the Civil Division of this district, prosecuting a variety of complex civil fraud cases. Ms. Avery is a graduate of Yale University and Georgetown University Law Center, and is also a New Haven native and graduate of the New Haven Public Schools. We're also joined tonight by Dr. Sarah Picard, who is the director of the Center for Criminal Justice Research at the MDRC. Her work focuses on policy-level reform in the criminal justice context and how research evidence can best be translated into practice. Dr. Picard brings more than 15 years of experience in justice system research and reform. In addition to leading development efforts and setting a new research agenda for the CCJR, she's currently playing a leadership role on MDRC's Pretrial Justice Collaborative and is acting as a principal investigator on a study of 911 call diversion for individuals with mental health crises in Tucson, Arizona. Before joining the MDRC, Dr. Picard was the Director of Research Practice Strategies at the Center for Justice Innovation. She has extensive experience studying the use of actuarial assessment tools in court settings and has recently completed a study modeling the potential impact of risk assessment on pretrial racial disparities in New York City. She received her PhD in criminal justice from the Graduate Center at the City University of New York. We're also very honored to be joined tonight by Alexander Shalom, who is a senior supervising attorney and the director of Supreme Court advocacy at the American Civil Liberties Union in New Jersey. Attorney Shalom appears in state and federal trial and appellate court on cases addressing a wide variety of issues. He's appeared more than 95 times before the New Jersey Supreme Court on cases focusing on issues including pretrial justice, the right to counsel, sentencing, search and seizure, and public access to police records. As the director of Supreme Court advocacy, he oversees the ACLU New Jersey's work before state Supreme Court, where they also appear dozens of times each year. Attorney Shalom is a fellow of the American Academy of Appellate Lawyers, and before joining the ACLU, he worked as an assistant deputy public defender in Essex County. And with that, I would turn it over to first to Attorney Shalom to give us kind of a background about our topic tonight.
Thank you so much, and thanks for the invitation to be here at this event named after such a luminary, not just in Connecticut, but nationally. In my world at the ACLU, you hear a lot in lots of different spaces about the need to end cash bail. It's a pretty common mantra. And I want to suggest that it's the wrong mantra because it's may be useful, but it's certainly not sufficient. And my kind of hypothesis is that jailing people before trial ever because they're detained, because they're held on cash bails they can't make, jailing people before trial is anathema to the presumption of innocence. And that doesn't mean we can never do it, but we have to recognize that every time we do it, there is a tension that someone has been put in jail before they've been convicted of a crime. And in some systems, and it's going to differ in federal systems and state systems and from state to state, but in some systems, those who get jailed pre-trial don't often wind up getting jailed post-trial, meaning the conviction rate is sufficiently low that not only is it kind of a process point, but there actually are innocent people who will serve a large portion of a sentence for a crime that they are ultimately not convicted of. I think it's important in this conversation to think about why jail is bad, why jail before trial is bad. And it seems silly because I don't think anyone disputes the fact that jail is bad, but it's worth kind of breaking out the components that make it bad. It's bad, of course, because it's dangerous. It's bad because it keeps people from opportunities like housing and employment and healthcare and family connections. All of those things are bad. It's also bad because it increases your likelihood of being convicted after trial. It increases your likelihood of pleading guilty, or if you go to trial, of being convicted. If you go to trial and wind up getting sentenced, or plead guilty and wind up getting sentenced, the research shows that you're going to do worse if you were detained than you will if you were at liberty. So those are all really bad things. And I can mostly only speak for New Jersey, but I know it's true almost everywhere in this nation. We don't just jail too many people, but we disproportionately jail people of color. We disproportionately jail Black people and Latino people in this country. And especially, I'll speak from my experience in New Jersey. And so the last thing I want to kind of focus on is there are things we can do to reduce the number of people who are jailed pre-trial. And those are good because it increases liberty. It ensures that people have a right to go to work and keep their family connections and do better at trial. Those are all good things. We can also drive down racial disparities, but one does not necessarily follow from the other. So I think it is good when we create systems that are liberty respecting, when we create systems that make it harder for the government to jail people pre-trial. I also think it's good when we are deliberate about trying to reduce disparities in who gets detained. Both things are good, but one does not follow from the other. It's not true that just by reducing the number of people incarcerated, we will drive down disparities. We need to be very deliberate about both. And now let me return, and then I'll pass it back to you, Cody. Let me return to my kind of opening salvo about cash bail. I think cash bail is gross. I think the idea that we decide who goes free and who is jailed based on the size of their wallet is something that should offend us all. But even in systems that don't rely on money, if they don't value liberty, they're not any better. Which is to say, if we had a system that didn't look at all at money, but just jailed people who were born in odd number months, we would say that was crazy. Or if we just jailed everyone, we would say that was crazy. So getting rid of cash bail might be useful, but it's not enough. What we need is our systems that respect liberty, provide robust due process for those who are faced with jail, and systems that intentionally root out discrimination.
Thank you. Next, I would turn to you, Dr. Picard, if I may. And I know that one of the things that have already mentioned very briefly by Attorney Shalom had to do with risk assessments and some of the tools the system uses to try to evaluate pretrial detention decisions. I know that that's a significant aspect of your research. Maybe if you could introduce that topic to us as well.
Yeah, I think that pretrial risk assessment tools and risk assessment tools in general have been to support, theoretically, to support more release and to do a better job at sorting people who are at very low risk to come back into the system and letting those people go. I think one of the problems, there are many problems with risk assessment, but one of the problems is they work best in theory. So there's a lot of research that shows that actuarial tools outperform, in terms of accuracy, they outperform decision makers. But all that research is sort of theoretical. It's not applied research. It doesn't happen in practice. So it's very difficult to actually implement these tools in court systems, and many court systems, for a variety of reasons, fail to do so, to implement properly, or sometimes to implement it all. So they adopt a tool and then they don't implement it. In other words, they give results to judges, but those results are not actually used for any real practice purpose. Or they're sort of, I think, misused in one of a few different ways. One is I want to thank Alexander for that introduction, because I'm very much aligned with his thinking. I do think that bail reform in general is good, but it doesn't actually proactively solve some of the problems that we see. So I think that's important to remember. However, money bail has a tendency to keep people in general, and Black and brown people especially, detained at higher rates. Pretrial supervision programs are a somewhat popular alternative, but they also don't fully address disparities, and oftentimes courts refuse to take bail off the table. So something like pretrial supervision or pretrial services are not used as an alternative to bail. They're used in addition to bail. And this is a very bad idea because people who can't afford bail won't get out at all. So your pretrial services program is actually not helping, and particularly not helping poor people and people of color especially. So I've seen this in like many jurisdictions around the country. I think there is definitely a problem with, I'm not sure that everybody who needs to sort of think through and potentially accept some of the things that Alexander is raising up about money bail are doing that. So risk assessment in theory should be useful in releasing more people in general. But it all depends on what mechanism is put into place for the use of that tool, and whether the use of that tool is consistent, and whether the use of that tool is actually to create conditions of release rather than to make a decision to detain or release. When you use a risk assessment tool for that like binary decision, it can create a lot of problems, and it actually defeats the purpose of what I think people who originally developed these tools hoped would be their use. Aside from that, there are, as I'm sure many people in this room know, because it's been a pretty public debate, there's a lot of controversy around risk assessments and racial disparities. Risk assessments and racial bias and disparities are like kind of two different things. So you can have a race neutral tool tested to be race neutral, is as effective as effective across all the races in like predicting a certain outcome, to the extent it can predict it at all, which is sometimes questionable, but it predicts just as well in Black, white, or Hispanic groups. So that then the developers say, okay, our tool is race neutral. We've done our job. But what happens is, because of historic biases that follow people into the system, the risk assessment data, which relies on things like criminal history or sometimes socioeconomic factors like employment, systematically overestimate the risk of people of color. I've worked in like, I don't know, probably over a dozen jurisdictions looking at these tools and looking at pretrial outcomes. Some are using the tool better than others, but I've never seen data from any place where African American and Latino people were not overly, like, disproportionately classified as high risk. And the issue with that is if the African Americans are disproportionately classified as high risk, they're also disproportionately assessed as high risk in error, because all tools have error rates in them, right? So if they're disproportionately high risk, they're disproportionately called that in error. So what happens then is a lot of people who aren't really high risk, and more Black and Latino people who aren't really high risk, end up with more punitive or more controlling conditions. So I think that's basically universal. It used to be thought that like if we just didn't include socioeconomic factors like employment or education or housing or whatever, that would make the tools race neutral. But it's become very clear that that is not the case. Criminal history-based tools are not race neutral. And if anybody wants to read like, you know, really good research on this and why it's important, I have lots of lots of documents I could refer you to. So I think the problem ultimately is, because I think the question for Connecticut is, we're seeing these patterns. We're not sure if we can fix this problem. And I guess I would say that it's very hard to fix it by adjusting your tool, especially in the legal context, because basically, in order to fix it, by tweaking your tool, you would have to, in some way, either explicitly or implicitly include race in your score. So race is a protected class. And so that it becomes very like problematic to the point of it, like not even like really wanting it on the table. Sometimes people try to take out the factors within the tool that are most associated with race, which is a good idea in theory. But what happens is you take these things out and the tool loses its ability to predict an outcome, which is, so then there's no point in using the tool at that point. So I think that to the extent that there are fixes, the fixes are going to have to come from policy. How you deal with people when they're released, how you use the tool to inform conditions of release, how aware you are in terms of how your non-monetary conditions of release might disproportionately affect people of color, and that you're thinking about that. I actually think that that's honestly the best way to fix the risk assessment problem. If you have the right services available for people, services that people will benefit from, will, then eventually some of the problems that get baked into the risk assessment tool will lessen over time. Right now, we don't have those kinds of models for the most part in this country. Most of our pretrial programs are supervision oriented. Supervision oriented tools are programs have been found to be not effective in increasing court appearance or increasing or decreasing the likelihood of rearrest across the board. We have done research on this recently, which I'm happy to share with people. But service-based models could be different, because we all know that regardless of someone's race, when people are released, some of those people have the kinds of problems that you can't expect them to be able to show back up for court or not be rearrested without some attempt to address those problems. So I always said, like, New York City RORs a lot of people, not as many people as they probably should, but they do ROR a lot of people. But then when the people do not show up for court, they issue arrest warrants. And an arrest warrant is issued regardless of whether you're homeless or you clearly have like a treatment need that's being unaddressed or a medical need that's being unaddressed. And my feeling is you need to know these things. And if you're going to ROR someone with some of these challenges or obstacles, it's okay, but you have to be accountable for it. You have to go get the person like from under the bridge, or you have to find them housing, or you have to at least temporarily. And I think too often our systems expect that supervision will act as a deterrent and people will rationally not like get rearrested or show up for court because someone's watching them. And I think this is like not actually true for the majority of people. And the last thing I'll say actually about risk assessment and racial disparity is there is some evidence that if you only use risk assessment in like more serious cases and higher level violent cases, that some of the racial disparities dissipate. That's because at the lower levels, there's much more discretion among police about whether to arrest people. And police often focus on communities of color when they are making any arrests, but also discretionary arrests. So serious and violent crimes are more rare, but they're also tend to be like the risk profiles of these people tend to be more equal across races. So I think that's a very interesting finding. Like we found it in New York, but I don't exactly know how relevant it is to practice, or how possible it is. So I leave that to you guys who do practice. But those are all my thoughts. And I'm going to be quiet now and hear what other people have to say.
Thank you. And I'll turn next to U.S. Attorney Avery, and I'm very happy to have you here as well. And I'd love to hear about pretrial release issues related to being U.S. Attorney in the federal system in Connecticut.
Absolutely. Let me first start by saying thank you, Cody and CBA and the Bar Foundation and all of your co-sponsors for inviting me to participate on this esteemed panel with Dr. Picard and Attorney Shalom. I think this will be an informative discussion, and I've already jotted down some notes on things that I think we can agree on, one being the need to intentionally root out discrimination in the policies that we are applying in the criminal justice system. As a former co-chair of this series, I am always delighted to take part in it and to make sure that we are discussing how best to address disparate racial outcomes in the criminal justice system. So let me just start there if I can. Having grown up in an urban community that was predominantly African-American and predominantly poor, household incomes at or below the poverty level, I know firsthand what it is like to live in a community that is disproportionately impacted by the policies and practices of the criminal justice system. Those who have heard me speak before know that I grew up in New Haven, Connecticut, in the Newhallville neighborhood during the 80s and 90s, and that was the height of the crack epidemic and the peak of gun violence around the nation, and certainly here. So my professional experience in this area is certainly enhanced, I think, by my lived experience, which includes, personal and ongoing connection to impacted people and communities. So I wanted just to start there to say that obviously I believe that everyone, regardless of race, ethnicity, religion, socioeconomic status, everybody deserves to live in a safe community where they actually are and where they feel safe. And so as U.S. Attorney in this role, I like to say that I have the best job in the world because my number one mission every day is to do justice. That's it. I go into the work every day and my job is to do the right thing. And to me, that means exercising my discretion and ensuring that all of the assistant United States attorneys in Connecticut exercise their discretion and discretion of this office in a way that is fair and equitable in all cases based on the law and the facts presented. And obviously, because of the long-standing societal root causes of what lead people into criminal behaviors, there has long been a disproportionate impact on communities of color. And so I wanted to just start there to lay that backdrop to make sure that people understand where I'm coming from as I talk about the policies of our office. Obviously, I agree with what Attorney Shalom said earlier, that a defendant is presumed innocent unless and until proven guilty in a court of law. And we should be very careful when we are talking about incarcerating someone before they have had the full due process that they should be given. So I want to talk about what that means to me, what that means in terms of how we address it in this office, and just give us some starting points for our discussion. So What that means is that a defendant is entitled to due process before he or she is detained. And we look to the Bail Reform Act, which for those in the audience who are less familiar with this area can be found at 18 U.S.C. section 3142. Federal prosecutors must present clear and convincing evidence to support pretrial detention. So that's certainly a hurdle that I think is important to highlight. And what due process means and what it means that a defendant is presumed innocent is that even after they are detained, a defendant is entitled to file renewed bond motions based on whatever appropriate sets of conditions and circumstances may exist. And they also may appeal adverse decisions on those motions. But what that doesn't mean is that every defendant will or should avoid pretrial detention. And I'm going to focus, obviously, on the federal level because that's where I practice and where the folks in my office practice. And I will recognize that there are differences between federal practice and state practice, which may come into play in our discussion. But at the federal level in Connecticut, if we are choosing our targets correctly and in accordance with the priorities that I have set for our office, those with pretrial detention will in most cases be those who have committed crimes of violence, especially those with multiple convictions or cases involving violence and firearms, child exploitation cases, sexual exploitation cases, illegal reentry cases when there is a danger to the community, and even in the financial fraud space, if there are serial fraudsters who are a danger to community because they're preying on elderly residents or other vulnerable residents. And then there are some cases where there is a real risk of flight, particularly for people who have foreign ties and vast resources. And let me just add before the discussion gets going, because I can see that my co-panelists are getting fired up now. Smiles all around. Victim considerations are also hugely important to the analysis. So obviously victims have a right to attend and be heard whenever pretrial detention issues come into play. And we also have to factor in witness protection and obstruction of justice concerns, especially in these more serious cases. So I want to add that in Connecticut, for at least the past 4 years, since 2019, we have had a federal court pretrial release and detention working group. This is a working group that is led by the district court, but it includes an AUSA, Assistant United States Attorney from our office, a representative from the Federal Public Defender's Office, a representative from the CJA panel, representative from probation, and a representative from the Marshal Service. And they are and have been looking very closely at some of the issues that we are, I believe, discussing tonight. And my understanding is that the overall goal of this working group, although I certainly can't speak for the court, is that they want to make sure that we are maintaining the high level of release rates we have in this district. Connecticut's pretrial release rate as of 2019, don't have the most current numbers, but it was 58.9%. It's the highest in the Second Circuit and one of the highest in the nation. And so the goal, based on some of the research that I think Dr. Picard was referencing, is that if a defendant is going to be released after arrest, let's do so on day one to decrease the statistical likelihood of recidivism. And we can talk about what that means and what that looks like. I'm certainly not a researcher, so I'm expecting you to jump in and give us more there. I think that might be a good place for us to jump back in for further discussion, but I wanted to lay out sort of where we are at the federal level, what we're seeing, and how I think this fits into the discussion. Thank you.
Thank you. And maybe I can, with introductions in place, just step back and say that it sounds like there is generally, I think, an unavoidable agreement that there needs to be a system that some people be detained pretrial and some people be released pretrial, and that there's an agreement that the presumption should be release. But clearly, and we have a question to this regard too, there are reasons why people need to be detained. So maybe I can ask you, Attorney Shalom, to start in terms of, you talk, particularly in your introduction about, the need to get as many people out of pretrial detention as possible. But where is that balance between the interests of detaining somebody versus, the considerations that go into the decision making?
Yeah, so it's a great question. And so you're right, first of all, that there is widespread agreement on a lot of things. The one bone I wanted to pick with U.S. Attorney Avery is you can't have the best job in the world, because I do. So you might have the best job in Connecticut, I'll give you that, but not the best job in the world. Can you say again, U.S. Attorney Avery, was it 58% release rate, 54%? It already is out of my head.
58.9%.
Yeah, so that is unusually high in the federal courts, and would be very low in the state courts, and that makes sense. Federal court prosecutions are very different than state court prosecutions in a lot of ways, including conviction rate, which is dramatically higher in the federal system than it is in the state system, and that's not just true in New Jersey. I think that's pretty universally so. The idea, though, that we should presume release it's not just coincidental that Dr. Picard and U.S. Attorney Avery and I agree on that. That's what the Constitution demands. So when Chief Justice Rehnquist was interpreting the Bail Reform Act that U.S. Attorney Avery referred to, he said, in our country, liberty is the norm, and detention prior to trial is the carefully limited exception. So we know, and every system must figure that out. Now, we could fight about what it means to be a carefully limited exception. I think that means it's like exceptionally rare. Other people think it's kind of rare, but it's got to be rare. But there are interests that have to be served. And in that case, that was United States versus Salerno. That was the first time that the U.S. Supreme Court said it's not just that we need people to return to court, it's also that we need to protect the public. That was a mob case, and said we can worry about the risk to the public and the risk of witness intimidation and things like that. There's a question in the chat, Cody, about risk of non-appearance. And I want to just spend a minute on that, because in a lot of places, at least before Salerno and many for a long time after, judges were considering risk of flight and non-appearance. They were considering danger to the community, but they were pretending they were only talking about non-appearance because that's what the law required. But I think there are a lot of myths about non-appearance. First of all, we often say we're talking about the risk of flight. And I don't doubt, and I'm sure U.S. Attorney Avery sees this much more often in her practice than I did in mine as a state public defender. But which is to say, there are instances where people have diamonds secreted and 15 fake passports, and they're going to get on their Lear jet and flee the country to some non-extradition treaty country. But that doesn't really happen very often. Most often, when people fail to appear in court, it's not because they've fled, it's because they're poor. It's because their lives are hard. So if we want to increase attendance, it's the solution isn't to jail more people or put onerous conditions. It's to give them bus passes or pay for their Lyft or Uber or give them childcare or hold court at more convenient times. And in New Jersey, one thing that we implemented as part of our bail reform in 2017 was text message reminders, right? So if you have a court date, you now get a message on your phone, the same way you do when you're going to the dentist or the doctor. And that we saw a 6% increase in people showing up in court just with text message reminders. And that's the one condition that no one really objects to, because it's not liberty impacting. It's like, great, so you give me a reminder. And it actually helps because people forget. Remote appearances I'm seeing in the chat, that's another thing. So those sorts of things, ameliorative things to make people's lives easier, to make the court process less onerous, to prevent them from losing jobs and things like that, those things would increase court appearances far more than jailing more people. Now, there are, of course, there are cases on the margin, but by and large, flight is not a thing in state court. Instead, what we have is non-appearance. There was a fascinating study that Megan Stevenson and some co-authors just put out that Sandy Mason was another one of the co-authors. And what it said is because it's a pain when people don't show up in court, even for one appearance, it messes things up. There's a docket, the judge is ready to go, the prosecutor's ready to go. Sometimes the victim is there or another witness, and it's a bad thing. But what their study showed is that the reason that we have these system failures where we can't go ahead with a court date most often are not because the defendant's not there, but because a police officer or an attorney has failed to show up. That actually happened more. I think they looked in, from 2010 to 2020 in Philadelphia, more often court appearances didn't happen because of non-appearances by attorneys and police officers than by defendants. So again, not suggesting it's not a proper consideration, but it's a little overblown, and there are ways we can make it easier by providing help to people rather than punishment.
And I know some of the answers have picked up on some of the considerations that go into pretrial detention decisions. And I know, in my own looking into it, it looks like New Jersey's often referenced as one of the first in the nations to get rid of cash bail systems. And I'd like to hear, and Dr. Picard, you talked about risk assessment tools, which I understand to be another kind of aspect of this decision-making process. So I guess my first question is there a limitation to trying to address racial disparities by just attacking the cash bail system?
Was that a question for me? Okay.
I was going to see who picks it up, but yes, you can.
Yeah. Can you repeat the question for me? I heard attacking the bail system.
Yeah. And so I'm trying to get granular. Is there limitations to trying to address racial disparities by just evaluating and making changes to a cash bail system in the state?
I think so, yes, because the disparities that are sort of embedded in the system and thereby embedded in the risk assessment tool eventually are not just, don't appear at the pretrial detention phase or the bond hearing phase. They sort of like they build as you go towards that phase, and then they continue to build, if you remain detained until your sentence. I think New Jersey kind of did three things. I think they introduced a risk assessment tool, and in a way they were very smart about it because basically they gave the assessment tool to the police. And they said, if you want to custodially arrest someone, they must have at least a 4 on this assessment tool. That later got pushed down to a 3, but that was their use of the assessment tool right at the front door. But then they also pretty much eliminated cash bail, and they created this, I think, tiered system of pretrial supervision. I think all these things theoretically would reduce detention across the board. And I think there's a longstanding assumption that reducing detention across the board reduces racial disparities across the board. And we have a study coming out very soon that shows that that's actually not the case. So I think cash bail reform is one good way to sort of reform a system that we know disproportionately affects people of color in general. But I think if you explicitly want to reduce disparities, not just reduce the number, you have to think about what you're doing with, post-release. If you're RORing people, then you have to think about whether that works in terms of resolving disparities. If you're if you have pretrial supervision program, which New Jersey does, you have to ask yourself, is that program doing anything to actively address disparities? And for the most part, I would say they do not, because they are very much focused on supervision, making sure that people show up by, making them come in to an office or something and talking. And there's service referrals, but nobody's required to take up those service referrals in general, not in New York, and I don't think in New Jersey either. They're just required to be on supervision. Maybe on top of that, they have to take drug tests or they have to wear a GPS device. So it's all kind of like supervision oriented. And I think to the extent that Black and brown people in the system are disproportionately likely to have some of the obstacles that Alexander was talking about, in terms of just practical obstacles to get to court. And then also to the extent that these communities are disproportionately affected by underlying problems that remain unaddressed when they're released pre-trial, which includes addiction, for the most part, behavioral health issues. So having a services-based model could actually help with this. And then I think it's interesting to me. I'll tell you something really interesting. And I've talked to a lot of judges, primarily in the South, state courts. I have very little experience in federal courts, so that's a weakness for this panel. But I'm actually very excited to be here because I think this is exactly the kind of conversations we have to have, because we all sort of see the same problem, but we're coming at different perspectives and thinking about solving the problem. But I've heard from many judges that mandatory treatment is a violation of someone's who's only accused and not convicted upon release. I understand and respect that opinion, but actually financial conditions are mandatory conditions for pretrial release. So they're really not different, but in the minds of practitioners who've been using them since the Salerno decision, they are different. They're not the same thing as, some other condition, whether it be therapeutic or supervisory. So I think that's a really interesting dynamic. And I'm not sure if federal judges feel this way, but I wonder if it's really, really accurate unless you're going to include the financial conditions in your perspective on that.
But there's one additional consideration on that, Dr. Picard, which is, and I don't have this study handy, but the last study I looked at on mandatory treatment showed a lower efficacy rate when it was mandated than when people sought it out on their own. So putting aside whether there is some liberatory right as a non-convicted person to not go to treatment, it also might be the case that it just doesn't work as well if you're forced to go. There's a question in the chat that I want to respond to, if I can, Cody, about whether education to reduce racial discrimination by judges, police officers, and probation officers is useful to counter the idea that defendants of color, quote unquote, look like criminals. It's a great question, and I think it's important, and it gets to, I think, a point that Dr. Picard was making about that you can do things within the bail system that might be necessary, but they're certainly not sufficient, because the bail system is, to the extent we're making decisions about pretrial release, whether we're using a risk assessment or a judge's intuition, that are based on a defendant's prior criminal history. And I don't know a system, state or federal, in the country that doesn't rely on criminal history as a factor in determining release. So as long as we're doing that, what we really need to do is make sure judges understand the way that racism in policing, in prosecution, in sentencing might lead a judge to be looking at two people, not knowing their race, but seeing only their criminal history and making decisions saying, oh, person A must be detained, person B may be released, when in fact the difference between person A and person B is simply the community in which they live, the level in which their community is policed. And so, again, mostly we're talking not about the most serious crimes, right? No one is doubting that if a police officer sees someone commit a murder or a robbery or a rape, they're going to arrest them and a prosecution will be commenced. Those aren't the crimes we're talking about that are kind of about hotspot policing. It's the drug offenses, the possessory offenses, even of firearms, that happen in some communities and don't happen as often in others. And so I'm also reminded, I wanted to just respond to Dr. Picard's point about police officers having access to our public safety assessment in New Jersey, which is true. And the kind of, I think, fascinating and counterintuitive research about the impact that had on driving down low-level arrests in New Jersey, custodial arrests in New Jersey, came from Dr. Picard's shop. But that's only with respect to low-level offenses that police officers were constrained in who they arrested. Obviously, police officers were making arrests for murder without looking at a risk assessment score, and they weren't making custodial arrests for jaywalking, no matter what the risk assessment score was. It was those kind of mid-range discretionary, I could arrest them or I could give them a summons cases, where they were more often given summonses as a result of the proliferation of the risk assessment.
If I can jump in here, I'm not going to speak to the low-level offenses that you were just referring to, Attorney Shalom, but I want to take a step back and address a few points that you dropped that I think are worth further discussion. One is just touching on the conviction rates again. Obviously, they're much higher in federal court, at least here in Connecticut, than they are perhaps at the state court level. And if we're going after the worst of the worst offenders, which is the approach that we have and the strategy that we have here, then I think we're probably going to be in a different circumstance than much of what we're discussing here today. So I just want to put that out there for further discussion or comment. But with regard to the pretrial release procedures and whether it's based on a services model, as Dr. Picard was laying out, or this risk-based model, I think at the process that we and the procedure that we're following right now at the federal level is probably a combination of both. I will tell you again that this working group that has been actively focused on this issue since 2019, one of our magistrate judges, Rob Spector, leads the working group, and at least one or two other magistrate judges are actively engaged in the working group. And one of the things that they decided is that we want to make sure that probation has time to put together the pretrial services report on people before they are required to appear for their initial presentment. And so a big part of our focus in that working group has been to make sure that when people are arrested and brought that they are brought to the United States courthouse by the Marshal Service by 9 a.m. so that there's time for a federal public defender or a CJA panel attorney to get there to confer with them, for them to have a probation interview with their counsel, and for probation to be able to put together this PSR, which will include a recommendation regarding release or detention based on what you talked about. You want to consider the whole nature of the circumstances of not just the criminal history, but what's the offense conduct. I believe their approach is based on a least restrictive release conditions. So we're talking about, is electronic monitoring an option that might work? Are there third-party custodians that might be able to help? And then talking about my third point, you talked about mental health and addiction issues. We have an active support court in all of our 3 seats of federal court here in Connecticut, which is designed specifically for people with addiction issues. And it's not mandatory. There is an incentive to participate, but it's not mandatory. And we've had good anecdotal success with that program. Some conditions may include inpatient treatment as opposed to detention, or even outpatient treatment while they're under third-party custodian or electronic monitoring. So certainly the things that you're talking about are things that we are already putting into practice here. I'd be curious to know if there were a study that was done or in the works to be done to see what some of the results might be. But I do think it's worth having the discussion and throwing that out there, that these are some of the things that are not just theoretical, but they're actually in place right now.
I think that's true. And please, I don't want to be misinterpreted as saying that I'm necessarily in favor of mandated treatment, especially treatment mandated by the court. I do think that if a court has a partnership with an independent pretrial services agency and they empower that agency to do assessment and create incentives for participation, then I think that's good. I don't know that there have been, if the question is, have there been studies of these conditions, I will say yes. But actually the services, I mean, I would love to see the study that Alexander is referencing, but the services models are very hard to test because the services are voluntary, and even if they're mandated, usually we're not tracking their participation at the actually program level, like at the addiction program level or at the whatever the other services, services might be. So it's extraordinarily, in my experience, extraordinarily hard to study. However, we're starting to try, and right now in New York City, we're about to launch some developmental research looking at specifically at people who have high needs and who continue to return to the criminal legal system over and over again, at like just focusing our resources, because many people have limited, services resources on the people that appear to need it the most, and also focusing our incentives or mandates or whatever they might be. And we're about to test that in New York. But that's not a services only model because there's still some supervision involved, but I don't even think at your level that you're speaking of, Attorney Avery, I don't even think that, I think that the mandating to conditions and services makes a bit more sense than some studies we've seen where people do not discriminate, or jurisdictions do not discriminate on how they use some of these mechanisms, particularly things like electronic monitoring. Like some judges and some jurisdictions just decide, I'm very risk averse, and so I'm just going to put a monitor on everybody, or everybody who has a DV charge or whatever. And those types of approaches are ineffective. They're very ineffective. However, jurisdictions that follow these sort of needs and high risk models and target their resources to those people are much more successful when they use these conditions.
Yeah, I mean, over conditioning is a real problem. You hear of jurisdictions where everyone gets required to be drug tested. It's like, well, but I was charged with, something that had nothing to do. Doesn't matter. Everyone gets drug tested. Those things. Right. I mean, I think there's actually some studies that indicate increased recidivism with overconditioning and decreased compliance with conditions when the conditions are unnecessary and onerous. I think it's also worth talking. I mean, we're talking a lot about two things. One is the kind of yes-no, detention, non-detention question, critically important. Another is the if released, how, right? Conditions, money, whatever it may be. I think there's also value in talking about the process, because I think that matters. I will tell you that when I came up as a baby public defender, I won't tell you how long ago, but a long time ago as a baby public defender, we thought of bail decisions as kind of unimportant. In the hierarchy of the stuff we did, it didn't rank high. Research and experience have shown just how wrong that was, just what a critical stage it is, and why advocacy from defenders and from prosecutors at that stage is so critical, because we know that the results of the ultimate outcome of the case are not dictated by, but predicted by what happens at the bail stage, and because of how it impacts a client or a defendant, depending on which side you're on, life. And I think there's always this tension between efficiency and process, right? Judges, not trying to disparage judges at all, but the judges with whom I've worked on bail reform in New Jersey want to make sure that it's not going to take them all day to process whatever it is, 10 detention hearings. And I think I come out on the other side. I come out on saying, this is so important. If you're going to focus on something, let's make sure that those hearings are meaningful. And so let me just give some parameters of what I think are critical to meaningful. And I'm guessing I'm going to get no disagreement from U.S. Attorney Avery, because I think these are sometimes more substantive hearings federally than they are in state court, in some state courts, I should say. So the first thing, and this is like, to me, a total line in the sand, non-negotiable, these hearings have counsel at them. If they don't, they're farcical. They're not real hearings, right? There must be counsel representing defendants at these hearings to make them meaningful, period. And at the earliest stage, right? The first time you're having these questions about detention or release or conditions, you need an attorney. The other thing is, whether there's a risk assessment or not a risk assessment, we need to know how the decisions are being made. And so in New Jersey, we use a risk assessment tool. It's got 9 questions. We all know what the questions are, and how they impact them. So we know that if you have 2 prior failures to appear, it's going to mean a point against you here. But if you only have 1, it'll be so we know exactly what it is. And that's important for a couple reasons. One, basic transparency and fairness. But the other is sometimes the inputs are wrong, right? So imagine, so there's wrong and then there's explicable. But so wrong would be if Sarah Picard, there was a failure to appear from 1971, and Dr. Picard said, whoa, that's not me. I was not alive in 1971. That's got to be my cousin with my same name or something like that. Those things do happen, those sorts of mistakes. And you need to be able to say, hold on, let's pull that out and count it differently. The other possibility is, you're right. I failed to appear on June 5th, 2014. That was the day my child was born. I was in the hospital giving birth to my child. I failed to appear, and then I showed up in court 3 days later to explain it, and the judge lifted the bench warrant. So there's those sorts of things. A real adversarial system allows for those explanations, both the errors and the explicable stuff. And then there's again, in a system that uses a quantitative risk assessment, someone to say, look, it's true. My score is, New Jersey uses scores from 1 to 6, with 6 being the riskiest, and there are 2 different metrics. And but so yes, my score is a 4.4, which makes it seem like I'm a moderate risk. But you'll see that it was my conviction for marijuana. If I didn't have that conviction for marijuana, then my score would be a 2.2. And New Jersey has since legalized marijuana. So judge, yes, it's a 4.4, but it shouldn't be given the same weight because it was such a de minimis violation. Things like that are important in advocacy. I think U.S. Attorney Avery talked about a right to appeal, absolutely critical. In New Jersey, it's an automatic right to appeal when you've been detained, but you have to be able to go to a different court. But the hearing itself has to be substantive. I think it can't just be a prosecutor standing up and saying, Judge, we have a really strong case. Because I will tell you, I have never been at a first appearance where the prosecutor stood up and said, Judge, we have a kind of shaky case. Sometimes the cases are shaky, sometimes they're not, but no one ever thinks they're shaky at this stage. And so there has to be some testing by the judge. And I'm not saying it's a full flown trial. But I think more process is better if you're trying to improve accuracy, to say, well, is this a strong case? Is this a person who's unlikely to show up in court, who's likely to harm someone else in the community? And so I think the more process you embed in that, and I think on this we might have disagreement about what that process looks like. I would like to see live witnesses and cross-examination. And I think there are other people who would say, well, a proffer by the government is sufficient, but the defendant should have a right to present her own witnesses. I think reasonable people can disagree about that. I think experience has shown these are so important that we need to make them robust and full with process. But I think the process itself is really important in showing that we're honoring Chief Justice Rehnquist, not something I try and do every day, but honoring Chief Justice Rehnquist's belief that liberty is the norm. And if liberty is the norm, we have to take those times when we're deviating from the norm seriously and put a pretty heavy burden on the state to prove it.
Attorney Shalom, I'm just so fascinated if you know if that's actually happening in New Jersey, because that was the ideal for these pretrial detention, that at least some adversarial thing would happen.
Yeah. So I do know. And the answer is some things have been great. So the first case we argued at the New Jersey Supreme Court was about discovery. How much discovery is a defendant entitled to before these detention hearings? And we won, and we get a lot. Basically, anything that the government is relying on to detain the person, we get. So if U.S. Attorney Avery was standing up and saying, Alex Shalom has been charged with murder, we have DNA, we have fingerprints, and we have witness statements, we would get the DNA, the fingerprints, and the witness statements. If, however, she stood up and said, we have these witness statements, we just get the witness statements. But you get a lot of discovery. So that was the first case, and we won, and we felt like, oh, this is the best system ever. We're so great. The next case, however, was called State v. Ingram, and we danced a little less after State v. Ingram. That was the question of, could the state proceed by proffer, or do they need to call live witnesses? Our statute is clear that if the government calls a witness, we get to cross-examine that witness. And so prosecutors were like, well, great, we'll just not call witnesses. And that is how we lost that case, if you didn't get my dancing joke, right? We lost that case. They said proffers were sufficient as long as they were testable. So in that case, there were some really weak proffers, and the court reacted to them with skepticism and suggested to law enforcement that they needed to come with more. They needed to say more about why there was probable cause to believe that the person had committed the offense and that detention was appropriate. And then in a subsequent case, a third case, the question was, well, what about if the defense attorney wants to call, everyone agreed the defense attorney could call witnesses. What about adverse witnesses? What about if the defense attorney wanted to call the complaining witness or a police officer? And essentially the court said, you can do it, but we're not going to let you harass people. So we want to make sure there's a check in place to ensure that they're a necessary witness. But if they're necessary, the defense can call witnesses at these hearings. So I think the New Jersey system does have process. If I got to pick, it would have a little more, but they're adversarial. And all of the things that I was talking about the checks on data and explanations, those things absolutely happen. I think defenders in New Jersey have done a really good job. And our data is all mucked up because of COVID, right? Everything changed in 2020. But from 2017 to 2020, we had detention rates of around 6%. So just to contrast, so 94% release rates, to try and use the same metric that U.S. Attorney Avery was using. That's probably crept up to 7%, so a 93%, down to 93%, but it's still pretty good. And one thing that and I'll promise I'll shut up now, but the thing that I think is kind of proof that the hearings are real is that when prosecutors seek detention, which of course they don't do in most cases, right? They're not seeking it in the penny ante shoplifting cases or whatever. But when they do seek detention, it's granted about 50% of the time. Now, one way to look at that is that prosecutors are over-seeking detention, and there are actually counties in New Jersey where I think that is the conclusion. The other way to look at it is judges are taking their jobs seriously to make sure there's a burden of proof. We have a presumption of release in almost every case. Make sure that prosecutors are able to meet their evidentiary burden to overcome that presumption. And I will just say, as a public defender, we didn't win that many things 50% of the time. There weren't that many types of motions where we had a 50% success rate. So I think judges have taken it seriously, and the adversarial system is working as intended in New Jersey. Not perfectly, but as intended.
And U.S. Attorney Avery, I was wondering if you could weigh in as well on the adversarial process, the procedural process that we go through in the district court, and if that has been changed at all. And I know that, you know, I've been to the pretrial release work group program and educational offerings as a CJA Justice Act panel member. But I was curious to hear your thoughts on the procedural process in the district.
Yeah, sure. Just briefly, I think Attorney Shalom is correct that, you know, I don't disagree. Okay, Alex, I don't disagree with generally what he's talking about, right? Representation by an attorney at the hearing, a transparent process where there's an opportunity to point out errors or other questions and issues that might bear on whether or not somebody's detained, like the fact that they were in the hospital having a baby the day that they were supposed to show up in court. And I do think there should be some substance to the hearing, but I imagine we would probably disagree on exactly what all those details look like. I think in the federal system, we have something that is essentially in line with that, as I've already outlined. I think the idea of making sure that arrested individuals are brought to the courthouse early enough in the morning so that counsel can get there, defense counsel can get there to meet with them, and that there is a substantive probation interview where they are also represented at that probation interview, so that the pretrial services report can be prepared. I think all of that is really a nice shift, making sure, you know, it's not going to be able to happen. It won't be possible in every case, but if they are arrested early enough that we can get them there by 9 o'clock and everyone can get to the courthouse by 9 o'clock, and then the initial presentment doesn't occur until the afternoon, that gives you the opportunity to do that. Now, of course, the federal courts are dealing with, in terms of volume, a lot fewer individuals than state courts. So this may be more difficult to implement at the state court level in a number of jurisdictions. But I do agree that that is generally the process that should happen, and that is a way to ensure that people's rights are protected here.
So I'm going to bring it home to Connecticut a bit too, and to say that, you know, I think that this panel is particularly timely because we're at kind of an inflection point in Connecticut, because the Connecticut legislature is poised to consider proposals to move our pretrial release system, and it's been referenced a number of times in the media, away from a bail-based system to something that's been described as more as a risk-based system. And in Connecticut, it would actually require a change to our Connecticut Constitution to affect our bail-based system. In fact, I want to say it was starting in January, there was a change to the rules in Connecticut that reduces what was a 10% cash bond system to a 7% cash bond system. That's rules that the judicial branch put out here. So, you know, picking up on the fact that the legislature in Connecticut is going to take up these issues from a policy perspective, I was hoping that we could all weigh in on what kinds of policy considerations go into play when trying to reduce racial disparities. And I know that there was discussion already about a service model, and, you know, drawing from a question that we received, you know, in terms of these public policy decisions that the legislature should consider to reduce racial disparity, you know, what does a service model look like? Is it something that's in practice in other states substantially? So maybe Dr. Picard, if I could start you off there.
Yes, there aren't a lot of service-based models, but I will say that Los Angeles County has accidentally created a services only model for pretrial populations, because they created this as a reentry model for people coming out of jail. And we've calculated that about a minimum of 40% of these people that are being served by this sort of service navigation model are pretrial. So there's no supervision, there's no reporting back to the court about whether somebody does their services, there's no drug testing, there's no electronic monitoring. And we did a study of it. I think our results may be slightly inflated because of the methods that we had to use, but nonetheless, we saw a significant drop in recidivism among people who voluntarily went to this program and participated, and people who got an assessment at this program but didn't participate. And I understand there's selection bias there, so we matched to try to get rid of that. You can never match perfectly to try to get rid of it, but I think we did a pretty good job. And so the study shows a 16% reduction in recidivism. That's very high. I think it's probably more like, realistically, it's more like, 8 to 10%. But it's much higher than we generally see when we study supervision-based pretrial programs. If they have any effect, it's lower, or to Alex's point, it's actually higher because they're putting way too many conditions on people at release. I think that Connecticut legislators should be careful if they want to transfer directly from a bail system to a risk system. I think they should really consider the implications of using a risk model or enforcing a risk model in terms of, reproducing racial disparities at the condition stage that are appearing in the risk assessment tool. But a services-based model, if you are gonna put on conditions or whatever, send somebody somewhere, even without it being a condition monitored by the court, these services-based models appear to be more effective than the supervision models, or the supervision models alone.
I don't want to jump on your toes, U.S. Attorney Aver, if you want to answer next.
Sure, I'll go next. I will be brief. You'll probably be more substantive. What I will say is, as this is a question for the legislature, and I am in a role that is apolitical, nonpartisan, and I don't engage in political advocacy, I'm going to really defer to the other panelists to jump in here. I think as far as the substance of what we do on the enforcement side, I think I've pretty much covered my thoughts there. Thank you.
So I'm not ethically prohibited from giving an opinion, but I don't frankly know enough about Connecticut to say more, but I'll say a little, which is, let me just tell you how I went about thinking about things in New Jersey, because we wound up adopting a system in New Jersey that I didn't like. It was not a system that, if you had given me a piece of paper and said, draw your perfect system, it wouldn't have been this. The system would have been far more liberatory had I gotten the pencil and paper. But what I had to do was say, what are we replacing? And what we were replacing was a rotten, racist, unfair system that it was wealth-based detention, where I had clients who I knew were only in jail because they were too poor. And there were other people who on paper and in reality were far more dangerous than my client, far less likely to show up in court than my client, but they were home because they had access to money. And that's an irrational system. And so we also had a constitutional amendment in New Jersey. We had, like you do in Connecticut, a right to bail, except in capital cases where the proof is evident and the presumption great, right? Same, but it didn't help people. It was a right that didn't actually provide protection because our courts had said that an unaffordable money bail counted as bail. So I had clients with, $500,000 bail on drug cases. There is something, and I'll get off my why money bail is dumb soapbox in 30 seconds. But there is something so irrational about the idea of money bail. So there's a case called Stack v. Boyle from the early 50s, a US Supreme Court case that said, if you set bail at an amount greater than that which is necessary to achieve the purposes of bail, appearance, protection, if it's greater than that, then it's unconstitutional. And then it violates the Eighth Amendment. But so what you have all these crazy cases where the judge says, okay, I'm setting bail at $6.25 million for this defendant. I mean, that's a serious case, obviously, right? But theoretically, that's a judge who said, oh, $6.1 million, that's not enough to make sure they show up in court. But $6.3 million, that would be constitutionally excessive. It's not rational. No one actually thinks that those things are true. We've just accepted the fiction that poor people or people without access to money can be detained for lack of funds. And that I don't think is a fair system. So all that to say, when you're trying to create a system here, I think you want to think about what are you replacing? And I don't think one should let the perfect be the enemy of the good, but you'll also probably get one shot to do it and do it right. I know that we're feeling that in New Jersey, and I think we came closer to doing it right. Other states are dealing with all this nonsensical backlash against their bail reform. And so I think you should really strive to get it right. And you should strive to be liberatory. You should strive to think about, are there ways to, even if you can't eliminate racial discrimination and racial disproportionality, are there ways to mitigate it, to rely on it less? And so, I mean, just give you the most basic example, right? There are all sorts of different risk assessments out there. There are risk assessments that look at zip code and use that as a factor in deciding how risky a person is. Those are deeply racist tools. There are other tools that are a little less racist because they don't use zip code, but they use things that are a proxy for it. And you should try and build a system that is as unracist as possible, even if you understand that any system that uses criminal justice data inputs is going to have a racially disproportionate impact. So liberatory, filled with process, actively trying to reduce racial disparity, and one that's workable. And I will say, and this is a lesson from New Jersey and one that I don't know how feasible it is, but to the extent you can get buy-in from all stakeholders, it will help. We had buy-in from our attorney general and prosecutors, from the judiciary, from the defenders, and it's made our reforms stickier than places that just kind of push something through because they have the political will and the political might, but they don't have the buy-in from people to bring about real systems and culture change. And last feature I'll suggest is make it be data informed, right? We have great data collection since we've gotten the new system, but we had really bad data collection beforehand, which makes the work of researchers like Dr. Picard harder because you obviously want to compare it to a baseline, right? And so start the data collection now, even before you jump into reforms, so you can figure out whether it's working, because we're kind of building the airplane as we're flying it. And so to the extent you're doing that, you want to at least be able to check down the road 3 years from now, 5 years from now, 10 years from now to figure out whether the system is achieving its purposes.
You know, if I can follow up with that response to Attorney Shalom, because I was very surprised. Well, I'm surprised to hear, and you know, spoiler alert, we actually talked about some of these issues before this panel. That you had mentioned that in the New Jersey system, when cash bail was done away with, and you have these more contested type hearings, pretrial detention hearings, that the overall effect was that detention went down across the board, but that racial disparities were not necessarily impacted in a significant way. And so you referenced building the plane as you were flying it. You know, Connecticut, if we were able to get the constitutional amendments to get rid of the cash bail system with buy-in from stakeholders, what thoughts would you offer in terms of how to improve, or how is New Jersey looking at any ways to improve the issues related to racial disparity in the system that it has now developed?
Since not everyone was on that pre-call, let me just give you the spoiler alert, which was right when our system went into effect, we saw about a 50% reduction in the number of people detained pretrial. That's tremendous. Before the reform, about 40% of our jails were Black people, though that's far higher than their proportion of the population in New Jersey. It's more than 3 times higher than their percentage of the population in New Jersey. After the reform, there were half as many people in jail, and still about 40% of the people who were locked up were Black. And so that racial disparity has persisted. I think there are ways you can be more intentional. And I think it's also important, and some of which New Jersey has done and some of which New Jersey hasn't done. I also think it's important to say out loud that it's not okay, that we're not just being like, well, that's just the price of doing business. And so I'm reminded of the following. In McCleskey v. Kemp, the U.S. Supreme Court was faced with data that they accepted as true that showed that imposition of the death penalty in Georgia was deeply dependent upon the race of the victim. You are 413% more likely to get death if you are a Black person who killed a white person than if you are a white person who killed a Black person, right? So it was this huge and stark racial disparity. And the U.S. Supreme Court said, to paraphrase, we don't care, right? Basically, they said, even accepting as true, that doesn't violate the Constitution. Justice Brennan, and I've got to give credit to New Jersey, Justice Brennan from New Jersey, in dissent, kind of chided the majority and said what it seemed like was they were afraid of too much justice. They were afraid that if we identified racism in the capital system, we'd have to then go after it elsewhere in our criminal legal system. New Jersey had at the same time a case, not the same time, right afterwards, a case where they said, listen, here's our view of McCleskey. If we identify racial bias in our capital sentencing in New Jersey, we're going to strike that system down under the state constitution. It might not violate the federal constitution, but in New Jersey, it would violate our constitution. That gave me hope and continues to give me hope that if we document either increasing racial disparities or even persistent racial disparities, there might be mechanisms for litigation under the state constitution to challenge that. But I'm not kind of giving you all a roadmap to suing your courts, though I'll tell you that it's something we think about here in New Jersey. But instead, what I'm saying is, I think what you need from all the stakeholders is a statement like the one that New Jersey made in that subsequent case of, if we identify racism in our system, we're not going to just throw up our hands and say nothing can be done. We're going to think about all the other system actors, police officers, prosecutors, defenders, judges, who are implicated in the system, and figure out the role that each and every person can play to try and drive down racial disparities.
Dr. Picard, maybe I could throw it over to you and ask, in terms of the social science component too, are there areas that you think are the most pressing for better data and more research in trying to address how these different systems we'll say that whether the federal system or other states are addressing racial disparities in their pretrial detention processes?
Yes, I think that, first of all, I just want to say that Alex is right, and everyone can call me Sarah, that all risk assessment tools are not created equal, and they all don't function the same way. Dependent on their functioning is dependent on their context, right? So one baseline thing to do before you implement a risk assessment tool is to test it, both for bias within the tool and for how it creates racial disparities in terms of outcomes. And a research partnership can help you do that. The one thing I think that is very helpful, but understudied, underutilized, is there are types of analyses. Some people call them path analyses. Some people call them structural equation models. But basically what it does is it picks something that is like a proxy for cumulative disadvantage, like a longer sentence, right? And then it maps out using statistics how disadvantage compounds at each point in the system based on race. And a lot of times, if you just do a direct study of like whether Black people get longer sentences, there won't be a direct effect, right? Like you may see that they get approximately 6 months longer of a sentence, but there's no direct effect between the sentencing point and the outcome. But if you follow from like the arrest point and then you go through the first appearance and bail setting, and then pretrial detention versus release, or pretrial supervision versus detention or bail, you can actually map out how disparity is happening in your system. And sometimes that's very helpful. If you show that to stakeholders, then they get like concerned. They get like more invested, especially if they see that like some of the disparities are being created at their decision point, or a decision point where they have some say. I don't know if I'm answering your question or not, but those are my thoughts.
And I don't know if there's data on this, but have you seen anything regarding racial disparities between systems that are more reliant on cash-based assessments versus ones that use a higher degree of these risk assessments? Because I know we've talked, about how these risk tools can have proxies that ultimately, kind of default back to, quasi race or, racial issues. Is there any data on that you've seen?
Oh, about whether certain factors are proxies for race?
Yeah, and whether the systems that use those risk assessment tools actually, or, a risk related, those risk tool systems that rely heavily on those, are they, any better at addressing racial disparities in pretrial detention?
I don't think so. Mostly because the tools aren't designed to address that, and also because usually they're mixed with judicial discretion. And if you do have any implicit bias in your judicial discretion, that will kind of like override, anything in the tool. The question in the chat, yes, I think these tools have been challenged. One was very early on, a very long like risk needs assessment tool that scored, was challenged in, I think it was like Michigan, somewhere like that. And it made it to, I think, the state Supreme Court. And then they were like, it's fine because the risk assessment isn't the only factor that's being considered. So that's a weird answer in my opinion, but I'm no judge, so I don't really know what the rationale is. A lot of people have written about the problem of error rates, and I will make the caveat that I also work for a nonpartisan research institution. So when I give my perspective, it's based on what my research is telling me. But I do think that it's important to like translate your findings. It's important to say what you think they mean so that people can consider that as they're going along. There's a lot of debate about error rates, and different tools produce very different error rates, and that depends on a lot of like just weird technical things, like how long do they track people after they are released, and to see what their recidivism rates are. But average tools, like a good error rate, I would say in this space is 25% wrong predictions. Is that a good error rate? Like from the perspective of like statisticians and researchers, mostly not. Mostly we feel that if you're incorrectly placing someone in a risk category in 1 out of 4 cases, that's kind of a drag, like in terms of like accuracy. But that's the top of the game. That would be considered an excellent accuracy rate in the field. And then it goes down from there. And basically, the closer you get to 50%, the more you can say, well, this tool is actually no better than chance. So I think a lot of jurisdictions are accepting subpar tools, maybe because they don't want to question researchers who recommend them. I think you should question them. And you should ask yourself if 25% error rate is good enough for you. The only thing I would say in defense of like some error in these tools is that if you are able to study error rates based on judicial discretion, they're typically much higher. So, it's a relative situation.
Yeah, so I just want to echo that point and some other stuff that's come up in the chat, which is it's not that you either have a money system or a risk-based system dependent on quantitative risk assessment tools. There's also in between, and I think, and in between, there's a risk system where the judge makes the call. And I think no one serious, at least these days, suggests that we should have a quantitative risk assessment that spits out a number and that dictates someone's freedom or liberty. Everyone agrees that there's some level of judicial discretion. And so the extent to which the judge makes the call really does change a lot of things. But judges get it wrong. I mean, and judges have either explicit or implicit bias, and sometimes both. And that's a function of human nature. And so that's another thing that kind of inspired me to get behind a system that I didn't love, was that I knew that the system that I had been dealing with for years as a public defender, that my poor Black clients were doing worse than rich white people. And I knew also that I was never going to be able to prove that, right? That the ability to quantitatively prove that would be absolutely impossible because there were enough distinctions that judges could draw on. But I hoped that a system that was had more of a paper trail would potentially lead to the ability to bring about the sort of important change that I think is needed.
So I understand that there's a pretrial risk assessment tool that was developed by the Administrative Office of U.S. Courts that's generally used by the United States Probation Office in terms of pretrial evaluations, assessments done in the federal system. So I was going to have to get U.S. Attorney Avery if that's something that you've come across, or how much interaction there is between the government and U.S. probation in terms of working through the decision-making process and advocacy process for pretrial detention decisions in the district.
Yeah, sure. I think, this ties in with what we were talking about before, the preparation of the pretrial services report and how that is used at the initial presentment hearing. I think, to take a step back, we're discussing a lot of the reasons for pretrial release, but taking a step back and putting on the prosecutor's hat, there are a number of legitimate reasons for pretrial detention, or at least for release with a number of pretty serious restrictions. And obviously, again, we're talking about the goal being at the other end of the spectrum. But when I think about the types of defendants that we are targeting in our cases, people who have committed multiple murders and attempted murders, for instance, or people who have who have harmed our children in ways that are unspeakable. We want to make sure that those folks are certainly going through this process, but we want to make sure also that at the end of the day, if it's appropriate that they be detained, that we are able to do so. So I think the tools that are used have to take into account the victim impacts, which are so significant, very real victim considerations in a lot of these cases. And not just looking at the direct harm that's caused by defendants in some cases, but also the trauma and the other impacts that are less tangible. If someone is a true danger to the community, as I mentioned, we do a lot of fraud cases here as well, our financial fraud cases. Elder fraud and elder justice is a big priority nationwide for the Department of Justice. And there are a number of people who are serial fraudsters who are absconding with people's life savings. Might not be millions of dollars, but it feels like millions of dollars if someone's funds are gone. And what do we do in those cases with those people if we think they might try and abscond? The risk of recidivism or committing new crimes on release, that's not a theoretical risk. There are very real examples, and several of them in some of our recent cases. One in which someone committed a murder while on pretrial release recently. So I think we have to make sure that when we're talking about what makes sense in terms of the balance, that we're taking all of that into consideration, and then also look at what are we doing to intentionally root out discrimination. This is a very complex issue, obviously, because we're looking at something that has longstanding societal causes, right? When you're talking about poverty and addiction and just the history of race-based policies and systems and racial discrimination that really factors into all of this, it's a lot more complicated than just saying, let's use this tool here or use that tool there. So that's a long-winded way of saying, I think that the assessment tool that's in place and in use at the federal level right now tends to provide a lot of the balance that we're talking about, but no one tool is going to be perfect, and we're going to have to continue to assess as we go.
Thanks. And U.S. Attorney Avery, if I can ask you one more question in terms of, I know that the working group on pretrial release is an ongoing process, and maybe to give myself an unfair advantage, do you have any sense of what other, policies or what other changes or thoughts the working group has moving forward in terms of pretrial release decisions in the district?
I'm going to have to throw that back at you, Cody. I will say that there is an annual training that the working group does, and the most recent one was just last Friday on December 1st. So I was not able to sit through all of the training myself because I had other things going on, but that is certainly, I'm sure, information that I could circulate to the attendees, to you to disseminate to the attendees for today, whatever information might be publicly available from that training. I know that there were participants from all of the agencies that I mentioned that participated in that working group, including people from our office.
Thank you. So we're going to be moving into the lightning round, where I'm just going to make sure that anyone who is a participant, if you have any questions, please be sure to put it in the webinar chat at this point, because I'm going to ask each participant, each of our panelists, kind of for their final thoughts as we get towards the end here. And I was going to put it in the context of, we talked about how Connecticut, may be on the precipice of seeking some kind of change to its pretrial release system. According to a Connecticut Sentencing Commission report to the governor in 2022, despite the fact that our prison population in the state of Connecticut has declined since 2010, our unsentenced population has actually increased. And since July of 2021, it's up 13%. As of January 2022, we had about 3,500 presumptively innocent defendants that were being held. And the pretrial population, as of that point, comprised almost 40% of our total incarcerated population in Connecticut. And I know that we talked as well about how the decision to detain or release a defendant on bond really substantially impacts the entire course of their criminal case, and we could say their life. And we know that we talked about how there are interests in stake that are involved in making that decision. But, you know, we also, in terms of the legislature's consideration, and this was something that came up during our last legislative session, and there were a number of community groups, you know, that have come out, the bail industry, public defenders, prosecutors, advocates, that have raised concerns that making changes to our system will have a negative effect on people of color, which is, you know, the majority of incarcerated people in Connecticut. So I would ask, you know, maybe each panelist, you know, in terms of what perspectives you would leave for the Connecticut legislature as it contemplates how to put in place policies that will improve, I guess, the racial justice component of pretrial release decisions in this state, based on your academic research and your experience litigating in other states in the federal system. And I asked an extremely long question so that you had a chance to think about it while I was asking. And so maybe if I could put you on the spot first, Dr. Picard.
I don't mind. I think that probably, you know, removing or seriously constraining the use of money bail is an effective way to reduce racial disparities, or not really disparities, but the disproportionate impact of the system on people of color. Because as you said, the majority of people in incarcerated in Connecticut are people of color. With that said, I think we've talked a bit about this already on the call, I think it really depends very much on what you replace it with. And if you're going to use a risk assessment tool, it should be thoroughly tested by somebody who knows how to test it, so that the legislature is aware of, you know, potential bias within the tool or potential disparities in pretrial outcomes. But I don't think, you know, this happened in California, actually. They were going to go with a risk assessment-based system before they went with their zero bail system that they have now. And mostly advocates that were concerned about the racial bias baked into the tool protested the tool. So the tool was taken off the table altogether. I'm not sure that's great either, because you just have an absence of money bail, and it's like nothing's been planned in terms of how to deal with the consequences of the removal of money bail. So I think you need a system of like improved pretrial supports and higher awareness among decision makers. Yeah, I think that's the best you can really do. I don't think a risk-based system by itself is great either. If I had to pick between that and money bail, I'd probably pick it, but I wouldn't be thrilled. So yeah, I think the debate is like very polarized and unnecessarily so about risk assessment tools. It's like either you love them or you hate them. And I think that this handicaps us in terms of what we actually do in practice. I think it only serves the desire of the advocates on either side to like be heard, and not the actual people that are coming through the system. So I think if you can avoid the Connecticut legislature falling into that, like, sort either it's great or it's evil trap, that would be also very good.
Thank you. Same question to you, Attorney Shalom, if I may.
So I guess the short version of my advice is not going to give you the answer, but it's about the process, which is if you hear concerns from defenders, listen to them. If you hear concerns from prosecutors, listen to them. If you hear concerns from judges, listen to them. If you hear concerns from the bail bond industry, ignore them. They are not credible. They are seeking to perpetuate a system of economic exploitation from which they benefit. And they don't have the best interest of people. So I say this from experience. In New Jersey, the bail bond industry brought to New Jersey to lobby a very august national civil rights organization. And you heard testimony about how the bail bondsmen are the best friends of poor people. They're the best friends of people of color. But that organization had been bought and paid for by the bail bond industry, who want to perpetuate the status quo because it's working for them, but it is failing communities. And I think there are legitimate things out there. And so, again, I'm not dictating what the results should be, but as a process point, I would trust the people who have constituencies, be they prosecutors, be they defenders, be they judges, but not the people who stand to be economically enriched by a system of wealth-based detention.
Thank you. And the last word for you, U.S. Attorney Avery.
Thank you. I am going to agree with some of the points that Alex just made, which are, you have to take a step back and look at the full picture. And I think Dr. Picard is making the same point, right? I can't advocate for any particular position, but what I will say is asking the question, sort of, what are the limits of this idea, this concept of just having a system where there's no pretrial detention at all? Are there circumstances where pretrial detention is appropriate? I would argue yes, and I've already talked about those situations. So, what are and are there situations where there is some pretrial release that's appropriate with certain conditions? How can we make sure that those conditions are appropriate? If we're talking about third-party custodians, how do we make sure those custodians are actually appropriate for the task that they're asked to do? And how do we make sure that victims are fully taken into account when we get to these cases that are at the margins? I think a lot of our discussion today has been talking about the folks who are probably easier decisions for pretrial release. And I think that's a fair place for us to have the discussion. But I think if you're talking about setting something in place that's going to be either set in statute or the state constitution, that you need to think more broadly about where those lines of demarcation are going to be.
Thank you. And I just want to thank each one of you again. I think this was an excellent panel, and I greatly appreciate all of your thoughts and insights on the topics we've discussed today. It was a wonderful panel. And with that, I'm going to kick it back to, I think, Ron from the Connecticut Bar Foundation. Perfectly.
Yes, thank you. Thank you to Cody and all our panelists. It was an excellent presentation tonight. I want to thank everyone who was able to join us and participate and ask questions and be part of the discussion. I also want to thank our speakers for sharing their knowledge and expertise, the Connecticut Bar Association and the Connecticut Bar Foundation for holding and continuing to support this speaker series. We will have more information available about coming events in the 2024 Constance Baker Motley series very soon, so please stay tuned to the Bar Foundation and the Bar Association for those details. And please, everyone, see the chat for more information about CLE codes, as well as a survey about your attendance at tonight's presentation. So thank you all again, and enjoy the rest of your evening.